Welcome back, everyone. It is now time for our second panel of the day, which is moderated by Professor Amy Cohen, who is the John C. Elam and Voorhees Seder Professor of Law at the Moorish College of Law, joining us today all the way from Australia. Professor Cohen's writings in areas from ADR to law and economic development and beyond have appeared in interdisciplinary publications as well as law reviews, and she has held visiting scholarships across the world. I'm so happy to have her here to participate in the event today, and not just because I have fond memories of my participation in her property class my first year of law school. I'll turn it over to Professor Cohen now to begin the second panel of the day.
Hi, Drew. Okay, there I go. All right, hello. It's good to see you all. It's good to be virtually back in Ohio. I come to you today from Sydney, Australia, on the unceded lands of the Bidjigal and Gajigal people. And I have the great pleasure to facilitate a panel of colleagues, between them just with an enormous amount of collective commitment to working in the space of intimate partner and family violence, including through imagining alternative, restorative, non-state and mediated processes. And so I think, does it make sense for me to introduce people one by one?
Whatever you'd like to do is fine.
All right. Well, so I think we're going to start with Donna Coker, who comes to us from Miami Law School. Donna is an expert in intimate partner violence, law, and policy. She has wide-ranging scholarship that examines the intersection of gender and class and race subordination in criminal law, and has worked for a really long time developing restorative responses to IPV and sexual harm. Her work supports a reimagined movement to end gender violence that moves away from supporting crime-centered approaches to demanding changes, including changes in the structures that maintain violence. She's a board member of Media for Change, and she's the co-originator of the multimedia project, Reimagining the Movement to End Gender Violence. So let me turn it over to her to begin.
Thank you so much, Amy, and thank you to Drew and Elle for organizing this and all the other students who are involved, and to Lee for reaching out to me. And to Miriam, who just gave an amazing keynote, and it's a hard act to follow. I'm so grateful for the work she does. So I wanted to start by, I'm going to be talking about restorative justice as a response to intimate partner violence, and a little bit about sexual assault as well. And as Amy was just saying, I come at this really from the perspective of what I have called reimagining the movement to end gender violence. And a big part of that reimagining project, if you will, is to move away from the kind of crime-centered kinds of responses that Daniel talked about this morning, that Miriam talked about, and in the keynote. And it's far beyond what I can do in my time here to try to describe how those responses came about and the feminist investment. I think it's a very complicated kind of story, but you can look at books by Lee, by Beth Ritchie, Aya Gruber, Kristen Buemiller, Marie Gottschalk, Andrea Ritchie, and of course Miriam's book that she was talking about, to look at history on that. But the feminist investment has been quite significant, and it has caused has been a party to some of the harms that Miriam described. And in addition, as Daniel and Kelly talked about this morning, at least not only has there been a feminist investment in focusing on criminal responses to gender violence, but there's been a really kind of taking in of what I call crime logic, but you might call it carceral feminism. And that's a set of beliefs that travel even in non-criminal spaces, for example, in the Title IX space. So when I say crime logic, what I mean is a focus on individual culpability rather than any focus on collective accountability, a disdain for any conversation about social determinants of behavior, a preference for narratives that center on bad actors and innocent victims, and a preference for simply removing, incapacitating, locking in cages, or removing from campuses individuals who've harmed as though they are unalterably damaged, invasive, and cannot change. So this has had some real impacts even in the most limited way of thinking about it in the domestic violence space. So we see domestic violence misdemeanor convictions freighted with collateral consequences that further limit the financial, economic ability for a person who has that kind of conviction by getting rid of occupational licensing, for example, substantial fees and fines and et cetera, all the kinds of problems that we see with the rest of the misdemeanor apparatus. And while this carceral state has grown as a product of, in large part of neoliberal policies and the longstanding founding nature of racism in our country, what little welfare state as that grew, what little welfare state we had has withered, as Dorothy Roberts, Lloyd Wycott talk about. And the hostility towards welfarism increased. And the result of this criminalization and these and kind of a punitive policies across the board, as Beth Ritchie describes, has been to make the lives of poor people ever more precarious. And a disproportionate number, of course, are people of color, and the continued kinds of racial inequalities coalesce with these policies. It makes the cost of involvement with law enforcement very, very high. And as we found in a 2015 survey published by the ACLU, we had responses from more than 900 domestic violence, sexual assault survivor service providers, and what we heard from them was a tremendous amount about law enforcement's bias against people of color, against African Americans in particular, but also against anyone who was understood to be poor, those that were believed to be sex workers, those who were believed to be drug dependent. I should mention that Julie is a part of that study. So the reimagining move then is to change advocacy and policy in many of the directions that Miriam was talking about, to focus on economic policies. We know that poverty is directly connected to the risk for intimate partner violence. It's to do the kinds of prison reforms that we've talked about and I mean that have been talked about on bail, reducing bail, getting rid of fees for services, et cetera. But it's also building trauma centers and responding to trauma in much more significant ways. It's community-based interventions, violence interrupters, thinking about violence in different ways. And for survivors who either choose to or who are forced into the law enforcement system, to provide less punitive responses that better meet the needs of many, and then for those who are not, to provide alternatives. So that's where that's how I understand restorative justice as fitting in, as being a part of this overall kind of plan. So now I want to talk a little bit about what is restorative justice. What do we mean when we talk about restorative justice? And then I want to talk about some of the processes that are commonly used, and I want to talk about Really picking up on what Jennifer Llewellyn said this morning, I want to talk about an anti-subordination restorative justice, borrowing a term from Angela Harris. So you could think of restorative justice as a way of life. And many writers and scholars and activists do. Howard Zehr talks about a way of life, a restorative way of life is taking relationships seriously, being aware of one's impact on others. And when you harm someone, even inadvertently, taking responsibility for doing what you can to repair that harm and listening deeply. You have whole school restorative justice approaches described by many, including Talia Gonzalez, that take this kind of approach to restorative justice. You also have circles, restorative justice circles for community building, for capacity building. You can read about that in some of the Campus Prism in that context response. But frequently, we talk about restorative justice as a response to harm, and that's going to be my focus. And restorative justice is understood to be focused, generally focused about who has been harmed, what are their needs, whose obligation is it to meet those needs. Sujata Baliga describes this aspect in terms of meeting the needs of survivors in this way. How do you define the harm? What do you need moving forward? What are your safety concerns? What are your material needs? How have you been harmed financially, emotionally, physically, spiritually? So processes that, so it's important to understand this relational kind of foundation. I'm going to come back to that again in a moment in the way Jennifer described this morning. Relational, yes, in terms of the individuals involved, relational in terms of their networks and the people who care about them, but also relational in the sense of changing the institutions and the culture and the networks, the familial and friend networks that support and maintain violence. So this work might happen in matched dialogue, meaning that the responsible person is in a dialogue with the person, the survivor victim, but it might not involve matched dialogue. So for example, family, friends might hold a circle with a survivor of intimate partner violence, and the person who caused the harm might not be there, but it's a way of pulling together the support systems and breaking through the kind of isolation that happens that Miriam was talking about. You also have programs like the National Compadres Network, which holds circles with boys and men of color to, and now I'm quoting, interrupt cycles of violence, generational trauma, and imbalance, and address the root of where the violence stems. And you have projects, restorative justice projects that are about holding institutions accountable. And then you also have surrogate dialogues. Domestic violence safe dialogue is one such example in which persons who committed a particular kind of harm meet with victims who suffered that kind of harm, but did not suffer that at the hand of anybody who's in the circle. But I think that most of us think about match dialogue, and that's certainly where a lot of my work has focused. And probably the oldest of those in the US, or at least the most well known, is victim offender dialogue. That's really only typically victim and the person who caused the harm and a facilitator. Conferencing has become much more common and is also the subject of a lot of research. And in conferencing, you have not only the responsible person and the survivor victim, but you also have supporters, family members, friends of each of those involved. Developed pretty very significantly in New Zealand from a Maori inspired kind of practice. You have family group decision making, and I think we're going to hear some more about that in a moment. But that is a similar kind of conferencing happening in the child welfare context. And you have circles. Circles could involve, could be matched dialogue, but as I mentioned, might not be. Circles tend to have larger groups and tend to have a more kind of fluid kind of conversation, but could come together around an instance of harm. And then you have peacemaking courts, and similar in the Native American tribal courts in the US. The Navajo Nation Peacemaking Court is one example. Some similarities with family group conferencing or other forms of conferencing. In peacemaking, as is true in some other forms of conferencing, you may also have people with particular expertise, alcohol treatment, for example, who may be a part of the circle if that's what the survivor wants as part of the circle. And we also have some batters intervention programs who have incorporated restorative justice principles and practices to some extent. The Circle of Peace program with Linda Mills and her cohorts developed is similar in some ways to conferencing, but it's in the form of a batters intervention program, and survivors may choose to participate or not, obviously. And you have differences in the relationship of these projects to governing institutions. Some community-based projects have no impact on what happens to the responsible party. Obviously, those programs that are connected to the criminal justice system and are a diversion do. So I want to talk quickly. I think I'm running out of time. I hope someone's going to tell me. I want to talk now about what the real benefits are. I wanted to sort of create a landscape here. But I think we frequently hear about the importance of voice validation and vindication, as Lee Goodmark writes, which affirms the victim's personhood and restores the victim's dignity. But it also, I mean, this is critically important. As Jennifer described this morning, restorative justice is comes from a relational theory of justice. So not only does a conferencing take into account the impact on the person, the survivor victim, but also the family members of both people and the impact that that's had on them. And it can be very, very useful in interrupting the social supports for intimate partner violence. There's a great deal of research that looks at the importance of social networks, for example, in the male perpetration of violence against female partners. There's a lot of research on the intergenerational aspect of violence, and in the COPS program, in Compadres, and the family group decision making, the program attempts to get at that intergenerational experience of violence. It takes into account, it allows a space to discuss the trauma, to discuss the violence and the harm that has very often been directed at the person who causes harm. As Sonia Shah, who is a restorative justice advocate with AHIMSA says, it gets to the cause of the cause of the cause of the cause. In addition, the conferencing can provide supports for survivors by reconnecting them with family members and with those with whom they have become estranged. And just a quick note here, I said I wanted to come back to Angela Harris's concept of an anti-subordination restorative justice. And by that, I mean the relational kind of justice that Jennifer talked about this morning. Harris says to truly restore justice means making right not only the wrongs of individual offenders, but also the social institutions that facilitate, reflect, and contribute to a particular offense. So I think I've run over time. I'm going to stop there, and I can pick up a few more things and questions and answers if there's time.
Thank you so much, Donna. Next up, we have Kelly Browe-Olson, who is the Mediation Clinic Director and also an Associate Professor of Law at Little Rock Bowen School of Law in Arkansas. She oversees, oh, hi, Kelly, it's good to see you. She oversees statewide special education and child welfare mediation projects, and she teaches family law, ADR, and domestic violence courses. She's also the chair of the Arkansas Parent Council Commission. She serves on the Arkansas Access to Justice Commission, the Association of Family and Conciliation Courts Board of Directors, and the Family Court Review Editorial Board. Welcome.
Thank you so much, Amy. It's a real pleasure to be here and speak to everybody. I am delighted to be here to talk about this topic. I come from a family dispute resolution background, and I'm here because I think there's a lot of overwhelming similarities between what's going on with the Title IX cases and what's going on in family law, or has gone on in family law in the past, I should say. The points I want to make go to the benefits of the informal processes that happen in these cases. We heard from some wonderful speakers today, and that really informed me about what I'm going to talk about. The pieces that I want to talk about are really trauma-informed advocacy. And I think our keynote speaker was so brilliant in her discussion about what we need to focus on and what we're not focusing on, both with resources, time, and energy. And I think that that was brought up this morning by Kelly and others when they talked about where are the resources going. They're going to the more formal processes. Now, Professor Goodmark and I have been talking about this for probably 20 years and talking about the paternalistic and maternalistic systems that are out there that are trying to protect victims. I came to domestic violence from mediation and asked people at the beginning not to throw tomatoes at me because so many people were anti-mediation. But I think that that was a view that was trying to be very protective of victim survivors, and yet was not empowering them in the way they can. And so when our keynote speaker was talking about transformative justice, I couldn't help but think about transformative mediation. And one of the people that I really relied upon when I started talking about family mediation and domestic violence was Trina Griot, who wrote a seminal piece about the problems of mediation for domestic violence victims, and really lots of victims, lots of people who didn't have the same resources that other people did. Interestingly, Professor Griot, before she passed way too soon, came back to mediation and actually became a transformative mediator where she worked on empowerment and recognition. And I like to think that those themes should come through when we talk about Title IX and what we should be doing with these processes. So I'm going to be focusing on the informal processes, but I want to talk too about how we've been through this with family cases. We've been through the need for formal processes where everyone is going to do exactly what the system wants them to do. And it didn't work. It didn't work for the survivors. It didn't work for the aggressors. It needs to be somehow done on a case-by-case basis. We need to think about what an individual survivor needs. Now, as Professor Cole talked about this morning, not all of these Title IX cases are about sexual abuse, but I'm going to focus on the ones that are, because part of what I think we should do is choose your own adventure. If you remember from as a child reading a book about what page you wanted to go to, I really think there should be a mix of formal and informal processes where the parties get to decide what they want to do. And unfortunately, some of the limitations, and some of you are watching are professors or students at universities, and you've had to go through electronic training about sexual harassment and sexual abuse. And there's just not enough information out there about what to do with that. Am I a source that if someone comes and talks to me, I can't say anything to someone else, or I have to say something to someone else? We're limiting the choices that survivors have when we create one path. So a choose your own adventure path. And the other reference I'll make is to Hamilton, my favorite musical. And I know some of the other people on the group like it as well. And talking about when Eliza Hamilton came back and put herself back into the narrative. One of the things I think we have done in some ways through these formal processes and even some of the informal processes is we've taken the survivor out of the narrative. And if she or he so chooses, I want them to be back in the narrative. I want them to be making the decisions about what happens to them, where their case goes. And as multiple people have talked about, restorative justice processes do that. They focus on what is the goal, where do people want to go from here? But I think we can do more than restorative justice. Yes, I think mediation should be a part of this. The other piece I want to think about is when we have these processes, what does justice mean for the party? When we talk about access to justice, and Jennifer, sorry, lost my train of thought there for a second. Jennifer Reynolds, who's a co-author on one of the articles but isn't here today, has just written an article and talked about access to justice and what it means. We have to take into consideration the actual processes and support that are available, but also what will people feel about the justice? So what is the goal of the participants, everybody in this process? What do they want to happen? Because too many times formal processes take all of that out of their hands. So if we take these pieces in family law, one of the things that we are focusing on when we work with domestic violence and interpersonal violence victims is we want to fit the process to the family and not the family to the process. And I see that happening in these Title IX cases as well. We're trying to shoehorn students and their issues into the formalized process because it does protect the university. It keeps it from maybe blowing up in a PR way, but we're not taking into account what a particular student and a particular situation needs. And I think that was addressed this morning as well. When we were talking about how there's different types of cases and we can't identify what should happen in a case without talking to the participants, without figuring that out. And that can be problematic. And like Brian was talking about, and he knows I'm a big fan of dispute system design, I think there are ways to design this that include a choose your own adventure piece. And part of that, the other piece that I want to talk about is what do we need to include? So I've got a video, we're going to try this once because I want to talk about IPV and specifically right now how COVID and the pandemic is affecting, this is about families, but I'm going to relate it to what's going on campuses as well. This is from the Battered Women's Justice Project, who does amazing work in this area. And I'm going to see if I can.
Opportunities for abusers. We can see, for instance, how an abuser can use this crisis to intimidate victims by forcing excessive hand washing or decontamination rituals, or by demeaning the victim's social distancing efforts. Emotionally abusive behaviors may include faking symptoms, defying public health directives, or confining family members to discrete parts of the home, among many other possibilities. An abuser can use a variety of isolating tactics during this crisis as well. This might include extreme social distancing efforts, or disabling the internet or phone service that a victim needs to connect with family and friends, their religious community, and the rest of the outside world. Similarly, abusers can use the COVID-19 crisis to minimize, deny, and blame others for their own abusive acts. They might accomplish this by denying the pandemic, justifying control as a social necessity, or claiming that they are just following orders like everyone else. They might also blame the victim for exposing the family to COVID-19. Battered parents have already reported that abusers are taking advantage of social distancing recommendations to weaponize children. In cases involving shared custody, they may refuse to return the children or even seek to modify court-ordered parenting arrangements on the basis of trumped-up COVID-19 concerns. With the economic downturn that COVID-19 has brought with it, economic abuse can be particularly damaging to victims. Skilled abusers are finding new ways to financially harm victims. They might threaten to kick the victim out of the house, refuse to work remotely, or engage in excessive spending by stockpiling supplies. Some abusers might find that they can further exercise their male privilege as well by taking up all the work and study space at home, or by demanding absolute quiet in the home during business hours. They could keep food or supplies to themselves, or demand constant attention, which keeps the victim from their other responsibilities. COVID-19 gives abusers ample opportunity to coerce and threaten victims in new and different ways. Abusers might exploit victims' fears of the virus by insisting that they're all going to die, threatening to expose the family or loved ones to the virus, or purposely engaging in risky behavior. The threat of withholding medical care as well can be particularly frightening for victims who are more vulnerable to COVID-19 due to health conditions. The dynamics of coercive control are the same as they have always been, but now abusers have many more tools at their disposal. In order to appreciate how confining coercive control can be in today's world, it's helpful to understand it in physical terms. Imagine the tactics surrounding the victim, effectively entrapping the victim on the inside, with no means for escape. In addition, an abuser doesn't operate in isolation. The tactics that the abuser employs are all reinforced by the surrounding social structures. In today's world, that includes the shelter-at-home orders that keep victims confined with their abusers, as well as racial, cultural, gender, and economic inequities that are woven into the fabric of Western society. In this way, the COVID-19 crisis adds to the dynamics that keep coercive control in place, making it harder for victims to manage risk, access services, and break free. This makes advocacy in the age of COVID-19 extremely challenging. Everyday life has been disrupted in unprecedented ways. Social and family life are different now. Although the tools of coercive control have changed, its dynamics have not. That means we know, and survivors know, what we're dealing with. While the risks to survivors and children have changed, the factors used to assess risk have not. We must continue to pay attention to established risk and lethality factors, as we always have. Although institutional resources have been drastically cut, many formal and informal supports are still available. Domestic violence agencies have been designated as essential activities under many state shelter-at-home orders. Friends and family and community resources are still there to help in many places. We can continue to draw upon what we already know to expose COVID-19 tactics, to identify specific COVID-related risks, and to provide individualized support, advocacy, and safety planning where we can. If you or someone you know is in need of support, please contact one of these resources. For more information, contact the Battered.
Okay, so I think, first of all, the Battered Women's Justice Project has great resources. And I think that some of the details that they talk about in that I share in my trainings really apply to our students now. And I think that it exacerbates the potential for abuse during the pandemic, but also the need for the informal dispute resolution processes, because it's hard to talk to students now. It's hard for students to talk to each other. They don't have those resources. And so I'm hoping with this new president and the new administration that we will see a return in some ways to more informal processes. Now, that said, there are cases that need formal processes. There are participants that want formal processes, and we need to include those too, because we did have dark times where women were taken advantage of and women and others were taken advantage of in mediation. So this goes to my training aspect. I really would love to see a lot more training. And the speakers this morning talked about that, several of them, about the need for it, but I don't want to underestimate how important it is, because I do this for a living. I talk about it all the time, and I still had questions based on the training that was provided for all of the faculty at my institution. It wasn't clear what we were to do. It wasn't clear when I could keep my students or faculty, colleagues, or staff's confidentiality, and when I couldn't, and when I was going to need to report, and when I could help them with an informal process. So I think we need to have, and I'll go back to Professor Pappas's presentation this morning, we need to design a system that works for the victim survivors, that works for the perpetrators so they know what to expect, but also works for everyone that's reporting and everyone that's advising the parties who are participating in this. I just have a couple of quotes that I want to talk about, because one of the latest things that I've been writing about is ACEs and trauma, and they're not the same thing, but they're connected. And I think that we will have students and perhaps colleagues and other employees who are traumatized by this, and we want to make sure that we are responding in an appropriate way. Couple of Dr. Judith Herman said, no intervention that takes power away from the survivor can possibly foster their recovery, no matter how much it appears to be in their immediate best interests. I know I've talked to colleagues who think that students need to report, they need to say what's going on. Maybe the colleague thinks that, but maybe the student doesn't think that. So I want to make sure that we have options for those students. And Peter Levine said, trauma is not what happens to you, but what we hold inside in the absence of an empathetic witness. And what bothers me and scares me a little bit is that the students and other people who experience these violent acts or the abuse or assaults aren't going to have empathetic witnesses unless we step up the training and the resources for these more informal methods. I could talk for a long time about all this stuff, but we have other great panelists, so I'm going to move on and be available for questions. Thank you so much for including me.
Thank you so much, Kelly. All right, so next up we have Julie Goldscheid, who's a professor of law at CUNY School of Law, where she helped to develop the Family Law Practice Clinic. Her scholarship focuses on, well, let me just get rid of the poll. Her scholarship focuses on gender equality with a particular focus on gender-based violence and economic inequality. Before joining the CUNY faculty, she worked at Legal Momentum, which was now Legal Defense and Education Fund, where among other things, her work included defending the 1994 Violence Against Women Act before the US Supreme Court in US v. Morrison. She was also general counsel at Save Horizon, which is a leading victim services organization. So welcome, Julie.
Thank you. Can you see me, hear me?
Yes, perfect.
Great, good. Thank you. Well, thanks so much to the organizers, to the students, Andrew and Elle, who've done an amazing job, to Lee for inviting me, to all the panelists this morning who have done a great job, and to Miriam for her really inspiring talk at lunchtime. So these are all hard acts to follow. What I'm going to do is switch a little bit to focus on the workplace. And I think what I'll talk about today will pick up on a number of the themes that were discussed this morning and that we've begun to discuss this afternoon. So my work on this project grew out of my observations about some of the responses to the, quote, Me Too revelations. I always put that in quotes, and about how the outpouring of attention and energy and concern with sexual assault and gender violence, and some of the critiques that evolved around those revelations paralleled responses to gender violence in other contexts that have been roundly critiqued. So my work has focused on gender violence across contexts. So to me, the Me Too revelations of sexual assault and sexual harassment at or associated with work lie on a continuum with gender violence that occurs in the home, intimate partner violence, with sexual assault that occurs in a range of contexts, and with other forms of gender violence outside of the workplace. And as I watched the public reaction to the Me Too response, the Me Too revelations, I was really struck by what Jennifer and others talked about this morning, with how the calls for strong responses and zero tolerance in response to those revelations really mirrored responses to intimate partner violence that have led to the kind of hyper-punitive responses and a focus on incarceration rather than transformation and social change and real accountability. That to me is at the core of what we need to be focusing on to really address gender violence. it caused me to worry that in the context of the workplace, those same kind of punitive responses, I think, what some have called carceral feminism, what Donna calls crime logic, would be increasingly imported to the workplace. So at the same time that we're having an increased concern with sexual harassment in the workplace, we're also seeing a rise in these kind of punitive responses. And I so appreciated the discussion this morning and the description of that, what you might think of as a version of sex panic that resulted from some of those revelations. So at the same time, when you think about the workplace, I was mindful of a parallel critique of studies and commentary that detail how sexual harassment and other anti-discrimination laws, much like the criminal legal approaches that have been used for intimate partner violence, also fail to promote meaningful accountability. And when I think about this, I think of the work of people like Joanna Grossman, who has written very persuasively about how our anti-discrimination employment law schemes promote compliance culture rather than truly ending discrimination. I think of studies showing that current practices may lead in the workplace to polarization and resentment rather than to really reducing discriminatory conduct and promoting true equality. I'm thinking of data that shows that the adversarial nature of anti-discrimination law imposes high costs on plaintiffs, especially African Americans and other people of color, and that the legal responses reinscribe rather than interrupt stereotypes about those in marginalized groups. And of course, this is particularly ironic and actually distressing when we think that the legal mechanism that's being used is one that is intended or designed to interrupt discrimination. So it's really working it's really counterproductive. In this legal framework, employer concerns with avoiding liability disincentivize reflection, apology, responsibility, and growth. And I think there are many parallels here to the Title IX context that we've been talking about all day. Yet since our predominant legal response to sexual harassment, which of course is a form of gender violence, is employment discrimination law, these two critiques, the critique of the hyper carceral focus in the intimate partner violence context, and the critiques of our employment law frameworks in the context of workplace discrimination really converge. As I stepped back and thought about these two parallel critiques, it struck me how our current liability system for discrimination really implicitly assumes that sexual harassment and other forms of discrimination is the exception rather than the norm. But if we consider the prevalence of sexual harassment and other forms of discrimination at work, we should instead develop practices that assume that discrimination and harassment will be embedded in the workplace. And we should create avenues for change for those who are willing to change. And that's one of the threads that led me to think about what role restorative justice practices could play in the workplace. So this project, the paper that I'm delighted to be able to publish, really builds on those concerns. It tracks some of the critiques that inform responses to the Me Too movement. It talks about restorative justice and traces some of the responses from the anti-domestic violence community. And then it explores how restorative justice might apply to workplace sexual harassment. And that's what I'm going to focus on in my time today. So I'll start by saying a few words about what has been done, what people have been doing with respect to restorative justice and workplace sexual harassment. Some scholars have begun to explore the issue. So Deborah Eisenberg, for example, she draws on organizational management theory and conflict resolution theory and anti-discrimination law, and has written very persuasively about how restorative justice practices could cultivate a learning infrastructure and a culture at work that can help prevent and address workplace discrimination and that could advance equality norms. Leslie Wexler, Jennifer Robinault, and Colleen Murphy also consider how restorative and transitional justice might address sexual misconduct in the workplace, excuse me, they talk about how core restorative justice values of acknowledgement, responsibility taking, harm repair, non-repetition, and redemption and integration could be helpful to survivors. There are a handful of articles. There are some consultants who are beginning to work on the issue. There are some interesting developments in practice. So for example, the New York City Commission on Human Rights, which is our human rights agency that is empowered to hear and adjudicate complaints, incorporates restorative justice remedies among the post-adjudication remedies that are available to victims of sexual harassment. So for example, survivors may include a mediated apology, community service, or reflections on what the harasser learned through trainings as part of the remedy that they receive if they prevail in their complaint. There are some unions that are engaging in non-punitive responses to sexual harassment that nevertheless give victim survivors a voice, and these are really exciting programs. And there are some practitioners who are doing things like educational coaching. So their work may not fall explicit within the restorative justice framework, but I think we could think about some of the work that they're doing within a restorative practices lens. So for example, there's one practitioner I know who's worked on sexual harassment for decades. She works a lot through unions, and she works with people who are accused of having committed sexual harassment, and she works with them, again, through an educational coaching way to help them gain understanding of what they have done and take responsibility for it. She has a very structured approach with clear criteria for who would be who would be eligible, who would be a good candidate for the coaching, and she works very closely with the employers to ensure accountability and follow-up. There are some NGOs and other groups that are and have been incorporating restorative workplace practices to their work, albeit maybe in an informal way. But overall, it strikes me that this area is really underdeveloped. So that's what I hope to address through this project. So what I do is I started to think about the context, the different contexts in which restorative justice has been used and the workplace context. And how are those contexts similar and how are they different? So of course, I'm very moved by the discussion this morning about the use of restorative justice in Title IX contexts. I think the comparison between Title IX and of course, college campuses and the workplace could be really promising and fruitful for developing further both theory and practice. But when you think about the traditional or maybe historical context in which restorative justice developed, the idea of interpersonal violence between individuals, we might think of the use of restorative justice in the workplace as slightly different. Because when we think about sexual harassment at work, of course, it raises questions of both individual and institutional accountability. And to that end, I again very much appreciated the comment this morning, suggesting that restorative justice, in my mind, might be even more suited to the workplace context because restorative justice opens the door and invites community accountability. And of course, that's all the more important when we're talking about the workplace. So some other contextual differences that might implicate the utility of restorative justice in the workplace are some of the power dynamics that come into play at work. So for example, if you think about sexual harassment of a supervisor by a worker, there are issues of the employee may fear retaliation, the employer may not want to undertake the vulnerability that often is entailed as part of restorative practices. And there, of course, are a host of other resistances to raising complaints at all in the workplace, owing in large part to people's needs for their jobs. But there are a lot of parallels between the challenges that people who suffer from sexual harassment in the workplace face and the challenges that other survivors of gender violence face that I think make restorative justice really worth considering when we think about workplace sexual harassment. And I'll mention a few before I close. So for example, the limited options for employees subjected to sexual harassment should cause us to consider restorative justice. Much like schools, employees are reluctant, if not unwilling, to file formal complaints for fear of retaliation, as I suggested earlier. Legal remedies, such as Title VII or other anti-discrimination lawsuits, may be really out of reach, either because of lack of access to counsel or the dim prospects for recovery through litigation, and of course, for fear of losing their job. But maybe more importantly, in some cases, employees subjected to sexual harassment, much like survivors of gender violence in other contexts, may not want to see their harasser punished. They may want to be validated and heard, as others have mentioned. They may want their employer to bear witness to the harm with some consequence. I'm reminded of a plaintiff's lawyer I spoke with who talked about how kind of serendipitously during a settlement conference on behalf of one of her clients, the employer apologized to the worker, who was a woman, and just how moved her client was. And it made me think, if we could create circumstances that could that could prioritize and could make apology more of a more frequent, what would that mean for survivors, and what would that mean for workplace cultures? So workplace relationships, much like relationships out of work, may be complex. Like other survivors, many employees subjected to harassment may want the harassment just to stop. And in some workplaces, particularly in small communities, someone subjected to harassment may be related to or friends with the harasser or the harasser's family. And like in cases of intimate partner violence, don't want them to lose their jobs because of the consequences, the economic ramifications of that change. And moreover, when we think more globally, punishment and termination, which is of course what people call for reflexively, just moves a harasser from one job to the next without really addressing the underlying issues. And as we know, and as we've talked about in terms of traditional formal processes, disciplinary processes at work haven't helped eliminate sexual harassment in the workplace. I've noted how in some of the research that and some of the reports coming out of the Me Too movement, what's prioritized, and I think rightly, is leadership from the top, training, anti-bias workshops, prevention as important. I completely agree. But one thing that's missing are mechanisms to explicitly create a space for and normalize responsibility taking, which restorative justice practices would support that kind of deep accountability measures. So the paper also addresses liability concerns. I think I'm out of time, so I won't talk about those now. They parallel in some ways the concerns around Title IX, although of course the legal frameworks are a little bit different. So I won't address those now, although I'm happy to answer questions. So I'll just close by saying that I think that restorative justice approaches are very promising as a way of addressing workplace sexual harassment, which, as we know from recent years, it continues to be all too prominent, all too prevalent, notwithstanding our decades of legal reform. So thank you very much, and I look forward to our conversation.
All right, thank you, Julie. Our last speaker for this panel is Charisa Keogh-Smith, who is also at CUNY. Her scholarship investigates popular capacity for decision-making and caregiving, harm and remedy in ways that undermine our over-reliance on state interventions. She co-directs CUNY's Intersectional Family Law Practice Clinic. She teaches juvenile law, torts, contemplative law, and like all of our other panelists, she mixes her scholarship with practice. She's represented children and adults in various fora, including through international experience in gender justice and combating childhood sexual exploitation. So welcome, Charisa. Thank you for being here.
Thank you so much, Amy, and thanks to the organizers. It's been a wonderful day and just so much work put into it. I really appreciate it. And it's always a treat to hear Miriam Kaba. I'm writing furiously and getting so much inspiration. So I realize I'm the last speaker before we close out, and luckily I have some slides. Hopefully that'll keep folks a bit interested. I'm going to share my screen. Hang on. All right. Folks, you can see the slides, I take it? Yes? Okay, you'll let me know if you can't. So I'm going to talk about, what some of these implications are of ADR approaches or non-carceral approaches as far as youth are concerned. And as Amy mentioned in her intro of myself, I've done work both, with adults and youth in various contexts in family, juvenile law, as well as in criminal law somewhat. But it's, been striking me, especially as the Me Too era evolves, what's missing in terms of our discussion of youth, and also the ways that the status quo legal responses actually don't account for young people's needs. And also, I'm very much in line with folks who are working on abolition in general. So working on, decarceration and, feminism that applies to gender-based violence without looking towards carceral solutions. So I'll do a quick overview of what this project is. This particular talk is part of a broader advocacy and research project I'm doing, then get into some of the terms that I mean. What do I mean by gender-based violence? What do I mean by youth or minor? And then talk a bit about some of the non-carceral responses I've begun to look at, as well as some concerns, right, that are raised by, trying to work on sexual and gender-based violence issues among youth without resorting to the legal system, without drawing on law enforcement at all, as well as some next steps for my work. I'm going to time myself as well, so I won't go too far over, excuse me. Okay, so as I mentioned, this is part of a broader project. I look at a lot of instances where there's overcriminalization of young people, as well as sexuality of young people. So I've written in the past about sexual exploitation of youth and some of our knee-jerk reactions to kind of, have a saving impulse or even a child welfare approach, as opposed to really trying to equip young people with tools to stay out of the cycle of getting in the life of exploitation, as well as looking at non-carceral approaches to the demand side. What does it mean to, stop people from actually patronizing young people for sexual exploitation? And how do we get at that part of the culture change as well? And so other work of mine looks at this idea that, with sexual and gender-based violence concerns among youth, the status quo legal landscape has three basic features that are problematic. A lot of the time we have this adult-focused blunt response or tool that kind of oversimplifies something that's unique to minors. So for example, that example I give sometimes is sexting among minors. Minors are, using phones or iPads and exchanging lewd pictures of themselves, and that's their business. A lot of the time it's consensual, yet the legal system looks at that as creation or exchange of child pornography. So there's even, a lot of requirements for sex offender notification and registration of a young person who actually has taken a picture of themselves and, sent it to a significant other or a friend's. And that tool, right, is not necessarily the right response, and it's not nuanced to the circumstance. Another feature of the status quo that's problematic in terms of looking at sexual and gender-based interactions among young people is infantilizing. So, sometimes we have child protection responses, surveillance, taking away young people's phones, even law enforcement monitoring the family, right? But not actually looking at the underlying reasons for why there's been a harm or for why there's behavior that might be problematic in some way. And then third, there's, a lot of neglect as well of actual response to instances of harm. And one of the key examples of that is in this realm that people talk about in terms of, maybe you've heard of the term revenge pornography. If a young person maybe has sent a picture of themselves to a significant other, a lewd picture or some kind of picture that they're not, fully clothed or some kind of supposedly compromising position, they may have sent that picture consensually, but then that picture gets released or posted on Facebook, or sent out to shame that individual once there's a breakup in a vengeful way. And so in a lot of states, there's actually no response to the victimization the young person has from having their picture disclosed non-consensually, because the person who's created that image is seen as guilty themselves of doing something wrong, or not, having any kind of victimhood at all. And so in previous work, I look at how to create a typology of these instances of harm, as well as a range of reactions or responses to different types of interaction and harm. In terms of minors, I mean people under age 18. And in terms of sexual and gender-based violence, similar to Professor Goldscheid, who just spoke, I'm talking about a real continuum of incidents. So I look at this as an umbrella term for everything from threats that are made, and also actual real-time acts perpetrated against a young person's will. And I'm looking at incidents among minors, so between people under age 18, specifically in this work. Everything from digital harassment to sexual harassment in schools to actual sexual assault or reproductive coercion, taking away someone's birth control or sabotaging use of a condom in a same-sex context as well. So I'm looking at a range of incidents that may be perceived as a harm in some way. So why do I think there's a need for non-carceral approaches? Well, a lot of time we forget that, as this Me Too era evolves and as the confirmation hearing of Justice Kavanaugh was such a flashpoint, that was about alleged high school peer sexual assault, right? People were triggered on a lot of levels that weren't even young people. But what's often missed in this era is the reasons why these incidents arise and the prevalence of this amongst young people. So I think that youth are at a crossroads of rape culture. They're statistically most victimized, yet the response systems are very much flailing. And they perpetuate cycles of oppression, these response systems: capitalism, racism, classism, patriarchy, homophobia, as well as just this urge to, over incarcerate. And, youth often, as do adults, seek responses outside of the bounds of what legal systems provide, right? Those remedies that you get in litigation, if you sue someone who has harmed you somehow in this context, are not really satisfactory. Also in the Title IX context, not necessarily a satisfactory response that a young person might get. And it's also worth noting that in terms of the Me Too era, Tarana Burke, who's known as the founder of the Me Too movement, right, that phrase Me Too, her organization, Girls for Gender Equity, actually focuses on the leadership and experiences of adolescents, particularly youth of color. But this point gets missed a lot in, all of this great, international consciousness and outrage. We miss also this voice of young people and the need to center that response in terms of our culture. So in the Title IX context, I'm not an expert in this area, and this morning's panel was really helpful on a lot of levels in understanding further of some of the shifts and some of the needs that are made with dispute systems. But just suffice it to say, in the K-12 educational arena, Title IX is also very woefully inadequate. Young people don't necessarily know the terms they have to say, right, to make an adequate report. Schools aren't actually notifying young people about the way to make reports, as well as not substantially getting into a proper response. So what does this youth culture look like, and what are some of the harms that might be experienced by young people? As I mentioned, there's a lot of prevalence, and people often miss this point. So 81% of students between grades 8 and 11 report experiencing sexual harassment, and just adolescent girls in general are the population most likely to experience sexual assault. I won't quote these other statistics, but suffice it to say that there's actually victimization most prevalent amongst young people. In terms of youth culture, right, we have, TV, we have music, we have movies, and adults sometimes get horrified. If you've seen this show Euphoria and you're a parent, it's like, wow, the kids today, right? There's a panic in a way, but there's also nothing new under the sun. It's just a lot of time with technology, with pop culture, things are even more sensationalized. There's immediate gratification. You're able to, create media, you're able to create images of yourself, you're able to, not have any privacy, and young people to a large extent want to be exposed in this way. This is, a way of expression. And I found this image really provocative from Vocal Media. This phrase, boys will be boys, we've heard that, right? But what does that mean in terms of sports culture, in terms of bullying, and actually the ways that schools do not respond to such a pervasive culture of harassment or abuse, in terms of, the sports culture victimizing young people who are gender nonconforming, or, victimizing girls as well, in a whole range of incidents. This image as well, just tried to be provocative here. How quickly can a girl go viral on TikTok? Spoiler, very quickly. Your child could be viral on TikTok right now. We don't know, but not to scare you. So I know I'm running out of time quickly, but in terms of what the harms are for carceral responses, there's a lot of link, right, between girls and young people generally who experience sexual victimization and the criminal justice system. LGBTQ youth are disproportionately incarcerated. And even research has been done about a sexual abuse to prison pipeline. So the reason that there's such a need is because these incidents don't occur in a vacuum, right? And it's not about bad actors, as many have mentioned in the morning panel and on this panel as well. There's a lot of parts of structural oppression that are just simply experienced and reinforced from an early part of life into adulthood. And there's often cycles that are perpetuated of intergenerational trauma or harm. And as Miriam Kaba mentioned so well, how are we going to address that? That actually accounts for changing everything, right? Not just these individual incidents. And so I'm looking at a range of alternatives in terms of non-carceral interventions. Everything from restorative justice and dispute resolution systems to bystander intervention or just other types of interventions that work on preventing these harms in the first place, or education. And these are not new innovations. In terms of America and the systems we're using or trying to get away from carceral systems, it is new, right? But there's many indigenous roots of restorative and transformative approaches. And working on notions of individual and collective harm and remedy is really important in getting to the root causes. Also, I just do distinguish in my work between dispute systems for discrete conflicts between individuals and their ripple effects of impact, and just broader interventions that work on the culture of a school, of a program, of a community. There's different types of interventions that I'm looking at. Not all are just for, my time is running up. Okay, so I'll finish up. Not just interventions that work on discrete conflicts, but also working on changing the environment that we're in. And these interventions look at truth-telling and catharsis as a means and an end towards reconciliation. So for example, there's, restorative justice programs that do healing circles. And Donna spoke about those, and she's done really incredible work on so many levels with restorative justice, so I don't have to speak much about that. And transformative approaches too are starting to be used in youth circles, but as Miriam Kaba said so well, it's a framework, right? And it's understanding that these other structural types of oppression are part of the culture that lead to individual incidents of sexual and gender-based violence and to harms that are maybe less individualized. So I will wrap up there and just looking at some concerns that, there's potentially red flags, right? If there's a mental health issue that a young person has, or if there's significant need for intervention, and also just that we, want to be aware of survivors maybe wanting their day in court, right? As well as Title IX concerns about, not having due process. But I feel that there's a lot of hope for these type of interventions. So I'll stop there. Thank you.
All right, thank you. So we have some time for questions, and maybe what I'll do is I have one question in the chat that I'll just read, and as others come in, we can put them to the panelists. So one of our participants asks, when these panelists see reforms in various institutions, what questions do they ask to determine whether the reform will affect substantive change? And maybe if I can just editorialize for a second, what I appreciated so much about this panel was how wide-ranging it was. We heard about reforms focused on the criminal legal system, Title IX at the university level, also K through 12, the workplace. And one of the things I think this question pushes us to think about, and that we know from history, including the history of ADR, is that we can design reforms to reconstruct systems, and they land up reproducing or recreating the systems we have. So I'd ask you all, in the spirit of this question, to say a little bit about the skills or relationships or structures you push on to think about how reforms will move us closer to a world we want rather than reproduce the world we have. And I think I could invite all of the panelists, Matt, if they want to turn on their cameras and just all join on the screen.
I can't turn my camera on. It says the host won't let me. Oh, it will now. Okay, thanks.
Well, I didn't talk about systematic issues, but I'll take it on before so everybody can catch their breath and then join in. I think that it's a great question because I think that we do end up replicating systems. We change them a little bit, we push, we change, but people don't like change, and people are opposed to it. So I do think that we need to make some big efforts. And one of the things that was said this morning, I think it was Kelly that was talking about how it's hard for her to change at the different schools and see. And I think with the Title IX issues, there's going to be a really big pushback from the universities and how they're looking at how they remain safe, what their PR and HR concerns are. So I do think that it can be incremental, but we also can't be afraid of just saying we need to flip the switch on this, because if we don't make some big changes, it's just going to settle down into the same patterns.
I would just add to that Talia Gonzalez did a lovely review of schools that have had success at whole school restorative justice for over 10 years. And what she found was consistent with what Kelly is saying. And that is that those programs began with big claims, not instrumental claims. They began by naming the racial impact of school to prison pipeline, by naming the punitive kinds of policies as being directly related to increases in mass incarceration. And they did that in the biggest way rather than the smallest way. And that built then according to Talia, that built the momentum then to go forward. I think the tendency is to think small, and I might even think that way, but I think that circumscribes your ability then to get where you want to go. So I do think that there's a lesson there from her work.
Do you want to go ahead, Julie, or want me to? I can't hear you. Oh, okay, I'll add really quickly too. I appreciate those comments, and I think something else I would add is just picking up on where Mariam Kaba, was talking about the idea of looking at who can provide help and who is problem solving in creating these systems. It's so important, it's like on the school level, but whenever you're trying to create alternatives to a type of response, like seeing who these people who might be using the system are and what they feel is the resource, what they feel are the issues. And in terms of school, like assessing what the culture is, like what are the incidents, what are things that we're missing, as well as like really asking who the gatekeepers are in this system, because a lot of time that kind of holds the key. If the gatekeeper is always a person who has a punitive hook to have as a result, right, that's going to make your system along the lines of kind of replicating the same thing versus looking for resources that are radically different.
I think just to add, Julie, I don't mean to interrupt if you were going to talk, but a couple of things Brian said this morning about dispute system design, and also Julie talked about the system that worked at Dalhousie. That was a big change, and I think you can model it. And if we can model something that works, like the programs that Donna's talking about, to other schools, and then I've seen this in the court system, judges listen to judges, lawyers listen to lawyers, caseworkers listen to caseworkers. If we can have those people model how to do it to the faculty and to the employees and to the students at another program, I think that will help too, how to have good, thorough responses that focus on the survivors.
I'll just chime in to say maybe two things. I love the question, and I think it really pushes us to think about accountability, because this whole project is really about accountability. And if you think about institutional change, accountability is such a challenge. And so I'm thinking a little bit about the climate surveys that I think are kind of one tool that has been used, but also picking up on some of the threads from Mariam Kaba at lunchtime. I think if we work with our current frames, we're going to replicate the same processes. And I think it's worth stepping back and really, I loved her image, her invocation of imagination. And I think for us with this issue, imagination has to be survivor-centered, and it may shift the ways we even think about what accountability or what measurement looks like. And I'll just say one small thing about sexual harassment at work. One thing that has so struck me in working on this project is the dearth of data about what survivors want. you know, when you talk about sexual harassment, everything, virtually everything you read is about discipline, punishment, you know, fire the guy, usually a guy, fire him. There's so little about, well, what does the survivor want? I've asked people, you know, like, how many survivors want an apology? How many survive, you know, like, and we just don't ask that question. And I think if we start asking, as you know, you all have said, if we start asking that question more, we might generate different answers.
No, I agree with that. I was just picking up on what Charisa just said too, and thinking, so the climate surveys that happen on campuses, I think for the most part, not entirely, but for the most part, are not connected with climate surveys about race, climate surveys about homophobia, climate surveys about what it's like to be an international student. And I think that, just to name a few, first generation, we could go on, but I think that this way in which sexual assault in that instance, but I could say some similar things about domestic violence, gets separated and held out as a separate kind of experience instead of understanding the ways in which all of these cultural experiences of subordination and all of the structures actually intersect. So I think maybe this is some version of Mari Matsuda's famous "Ask the Other" question, but I think that there is a real important, I think there's something really important about that.
Let me jump in with our next question. Again, I'll just read it. From a Title IX perspective, I'm curious to know how to apply this work from a gender studies feminist lens without appearing biased towards a respondent, and championing this work through the Title IX office without appearing to show partiality or impacting the credibility of the Office of Neutrality. And so again, I'll just editorialize for half a second, because I think this is also an important question for our moment, right? How to do facilitative work, but also work that we might understand as participating in a political or social movement.
Well, I have some thoughts about that. I mean, I think that there's a real risk, even with I shouldn't say even with, but there's a real risk with restorative justice work of importing some pretty deep gender bias and assumptions, very gendered assumptions about victimizing and who can be a victim that hurt men, and I think can operate in unfair ways, and that can hurt, that fail to see victimization in lesbian, gay relationships. I mean, so I think that there's, and I think I have been concerned that that's an issue in some of the restorative justice that I've seen, and it really sort of imports a lot of the most simplistic versions of that, you know, to use Julie's, that Me Too moment, however we express that, in the campus context, in the very hothouse political campus context. So I think that's I'm not sure I'm answering that. I think it's just a really difficult issue, and I think that the RJ can be is subject to the same kinds of political pressures that any of these responses are going to be subject to in those ways. And if that didn't make sense, ask me.
I think it made sense, but I also think that it's a really tricky question. So as a mediator, as someone who I like to think it tries to be as neutral as possible, I think these are really great questions, but I also want to focus on the narrative of the stories, and that we hear everybody's narrative, not just the narrative of the survivor. And even the terminology can get us into, you know, issues of, does someone want to be termed as a victim? And it's not just one incident, but then are they do they have to continue their victimhood, and how we're going to define people. So I think it's a really great question. I think it goes to the process, and what is the process, and who gets to decide what's going on in the process. I think what we've seen with Title IX is this flurry of cases where now offenders or potential offenders, accused offenders, are using the Title IX language to go into court to say that they were discriminated against. And they're using the formal processes in ways that we saw batterers use formal processes in family law to punish their victims. Now, not everybody that's filing suit is an offender, and we do have rights to do, everybody has rights to due process, but I think that there are ways to include both of this, but it is threading a needle sometimes, because we want to value everyone's story. We want to hear what's going on, and decisions need to be made. And if the parties are willing to participate in a restorative justice process, if they're willing to participate in an informal process, I think there need to be safeguards in place to protect everyone, because what we saw in the past was that the informal processes didn't protect the victims. And I think what we're seeing now is that the formal processes aren't protecting the victims either. And while they may be temporarily helping offenders because people don't want to participate in those processes, if the survivor is going to be re-victimized or have to go through everything again, I don't think it's good for anybody. So I like to say that the mediator's client is the process. And so I want to protect that process. I want, the dispute system design that Professor Pappas was talking about this morning to be used, and systems to be set up, but choices need to be made.
I just want to add one quick thing. I mean, that I don't think any of this said, and I might be wrong, but most of the time, a foundational principle is that for a match dialogue, restorative justice to occur, the responsible person has to admit to having engaged, at least in the conduct. And I think that for a lot of us, that really distinguishes restorative justice from mediation. And sort of tied to that is that, and speaking for myself here, there is an understanding of neutrality in the sense that the facilitator is responsible to care for everyone in the process, right? And to treat every person with dignity and respect. But there is another way in which typically restorative justice is not neutral with regard to the values. So, and I think that that's an important distinction, and I think it creates some complications and maybe makes it not the right fit for every instance in which someone actually experienced harm. So, and this is a much deeper kind of conversation than we can probably do right now, but I did want to flag that because I don't think that distinction maybe has come out.
So I actually think our next question maybe gets us to grapple a little bit with Donna's last comments. And the next question is about affirmative consent on college campuses. But the questioner asks, how do we reconcile a sort of very high bar for editorializing for affirmative consent that students may first encounter in higher education without having sexual education or education about violence before coming into a university setting? Is there a way that these policies can be folded into an RJ practice, perhaps, and again, I'm adding, rather than assuming that these are kind of cultural skills that people have at the outset? And that might be one way to talk about what people need to admit to at the outset of a process, and what can sort of be done through the process itself.
I want to give other people an opportunity to talk.
I'll take a stab at answering this, but more from a different frame, I guess. I really appreciate that question. And I think my answer is a little bit outside of the direct answer, but it has to be both and. In other words, if you're arriving at a post-secondary setting and you haven't had any sex education, you haven't understood like what consent even could mean, maybe you've received a lot of negative messages, or even, gender stereotyping, right? And then you arrive at college. If you actually do have an incident that, gets to a system of restorative justice, like, sure, there should be a lot of room for understanding common language and like education, as well as like understanding what harms can be, but also like just in general, there has to be more education and prevention and at an earlier level, as early as possible. And some schools are doing it well. There's been a good amount of legislation, in even high schools and middle schools. But I think it's a failure of our earlier systems that people would arrive at, post-secondary settings and then have to figure out like, oh, what does no mean, right? But this happens. So I'll let someone else handle more of what the systems can do, the RJ process, but the earlier the better. These concepts cannot be something that we just learn about as adults.
I so agree with that, Charisa, and I feel like I'll leave the direct answer, to people who have had more experience with RJ on campus, but it does speak to me to the importance of cultures. And, like with any dispute resolution process, it takes place within a culture. And so, if you have a culture where there's a conversation about consent and what it means, and gives room for dialogue, then it seems to me that the person who's posited in the question would come to a restorative justice process in a very different way than, if the RJ process is kind of separated from the rest of the culture.
I agree with both what Charisa and Julie said, and I would just add that I don't think we've talked about with a lot of detail. Maybe we did about remedial plans that can come out of a restorative process. And Sujata Balaga has a wonderful example. It's on Vox, VOX. You can find it. And so what happens in this case involving a high school student is that who's accused of sexual assault. He basically says to the young woman, "I thought you were into me. I thought you wanted this," and she did. She didn't want the sex. She was into him, and she says, when I said I'm not that kind of girl, I don't want to do this, that was no, and you know that. And Sujata describes the moment in which he sort of gets it. It's like this change occurs, and his mother turns to his sister and says, "I wanted you to be here because I want you to understand that even good boys like your brother can think like this." And part of the remedial plan then for this young man was not only what is very common, and that's education on consent, education in rape culture, education in the kinds of things that you would expect, and it also was about speaking to the friend groups who had been blaming the girl and telling them no, that you shouldn't blame her. And then when he went to college, becoming a part of the consent is sexy kind of work. So I think that's just an example, a very small example in an individual way of the kind of cultural shifts that an RJ process can be a part of.
Donna's story just reminds me quickly, I know we don't have a lot of time, of what they're doing in some junior highs and high schools now with football teams and basketball teams, where the coaches are leading these discussions. And I think the younger we start, the more we make it part of the culture that the boys are already in, and girls too. I think one of the things is that we can't just put this all on boys. I think that girls have set expectations, or think about others that wouldn't happen to me, or, oh, I don't do this, so that won't happen. And I think we need to educate both sexes, everybody, about what's going on, and start very, very young.
I just want to ask for a time check. Do we go until the hour or?
I think we're ready to wrap up in the next minute.
It's a quarter. Okay. All right. There's so many other good questions that I've just been scanning and preparing, but hopefully folks will have a chance to look at the questions in the chat and find other ways to be in dialogue and communication. So let me just thank everyone for these really luminous interventions. Wonderful. We really appreciate it.
Thank you so much. It's really, this has just been a real pleasure, and I'm really honored to be on the panel with these really amazing scholars.
Agreed. Thank you. Thank you all.
Pleasure. Thank you so much, all.
Thank you very much for inviting us. Even me, who's a Go Blue fan from way back when, got to talk at Ohio State, so thank you.
Thank you, panelists, and thank you, Professor Cohen, for moderating this panel. And thank you to everyone who's attending for coming to the symposium. For those who don't know, my name is Chase Dean, and I am the editor-in-chief of the Ohio State Journal on Dispute Resolution. I want to first and foremost thank all of our speakers and moderators for leading us in so many insightful discussions today. I'd also like to give a big thank you to Mariam Kaba for participating this year as our keynote speaker. And finally, and certainly not least, I would like to thank our JDR Symposium editors, Drew Factor and Elle Gerwig, as well as our marketing editor, Arian Thomas, and our Symposium editor from last year, Jamie Cardenas, for laying the groundwork for all the tireless work that they put into organizing this symposium amidst an unprecedented pandemic. JDR has never put on a symposium, to my knowledge, in this format before, so to be able to pull this off and deliver a symposium of this caliber deserves much recognition. And luckily, our symposium it is recorded and will be available in the coming week via our website. So keep an eye out for that recording. On a separate note, many of the speakers you heard from today are set to be published in our 5th issue of our 36th volume. So if you would like access to that, a standard subscription to JDR includes 5 issues. For more information on how to sign up for that, you can do that on the website. And additionally, if you would like to submit your work to JDR, you may do so by emailing osu-jdr@osu.edu, and we will take a look at your article and consider it for publication. As you exit, you'll be asked to fill out an exit survey. Please be sure to fill that out and provide us with any feedback you may have, as well as you should be receiving an email sometime tomorrow regarding information on the CLE credit. So thank you again, everyone, for attending, and those who spoke, thank you for speaking. I hope you have a safe and healthy rest of your year.